Good afternoon, everyone. Welcome back for week 5 of the AVCP Tribal Court Training Series. My name is Denise Nervy. I am the manager for the Tribal Justice Department at AVCP in Bethel. Thank you all for joining us today. As always, I would like to start off with our housekeeping reminder that these trainings are being recorded and we're all placed on mute to begin with. We ask that you remain muted unless
you can on this one. They have a lot of good information. See if they can email you.
Turn off your
Okay. So going back to our housekeeping, we would like to ask that you remain on mute unless speaking.
muting.
I'm sorry, I'm getting some background noise. I think we're good. So we'd ask that you remain on mute unless speaking, and to be able to unmute yourself on the phone, press *6, or on the computer, there's a microphone button at the top right-hand area of your screen. This week, we will talk to you about tribal court procedures, and today's presenters will be Judge Deborah Oguera, who is currently the Senior Policy Specialist at the Alaska Native Women's Resource Center, Rick Garcia, who is a tribal court facilitator at the Alaska Native Justice Center. Kevin Ellingworth is a professor with UAF. Estelle Thompson is a tribal consultant, and Nellie Wassily, the Tribal Justice Program Coordinator at AVCP. So now at this time, I'm going to share my screen and hand the mic over to Judge Oguera to begin today's session. Judge Oguera, can you confirm that you could see my screen?
I can see your screen, and can you confirm that you can hear me and I'm off mute?
Yes, I can hear you.
Perfect. That took a couple of tries. Okay. I can see your screen, and I'm hoping that everybody else can. I'm really excited about this. Of course, those of you who have worked with me or seen me present before, tribal court is really one of my passions, and I am so excited that there's so many tribal courts that are developing and up and running, and looking to expand throughout the state. So for those of you who haven't met me yet, my name is Deborah Oguera. I am currently the Senior Policy Specialist for Alaska Native Women's Resource Center, and most recently was the presiding judge for Tlingit and Haida, where I actually started there in 2007. And have been part of working with AVCP, which is one of my favorite partners to meet with, because you all are so passionate and committed to what you do. My family is originally from Wrangell, where I am just across the bay, or across the channel from Wrangell, and I'm residing now in Petersburg, Alaska, in Southeast. I am Tlingit. My Tlingit name is Tjijuk Suk, and I am also part Yupik. My mom was born and raised in Mountain Village up in the YK Delta, where you all are. So maybe that's why I like working with AVCP so much. So it reminds me of going home, where I spent my summers. Before we get started, I'm going to actually go through and have all the co-presenters who are with me today quickly introduce themselves. We'll start with Rick.
Hey, good afternoon, everyone. My name is Rick Garcia. I am a tribal court facilitator for Alaska Native Justice Center here in Anchorage. Before I was working with ANJC, I was a district court magistrate judge for the Alaska court system there in Aniak and Hooper Bay. And prior to that, I had the pleasure of working for AVCP as their Associate General Counsel and Tribal Justice Director. So I kind of want to echo what Deborah said. AVCP tribes hold a really special place in my heart, and I'm really grateful to be part of today's conversation.
And Kevin.
Hey, good afternoon, everybody. Kevin Ellingworth, and I am a professor of tribal governance at UAF. I've probably met many of you before. I wish we could be face-to-face. I really look forward to being able to see people again, and look forward to talking with you all today.
And Nellie.
Hi, my name is Nellie Wasley. I'm the Tribal Justice Program Coordinator with AVCP here in Bethel. I've been working with the Tribal Justice Department since 2019 on April Fool's Day, and that's when everyone was okay to work from home. So I haven't worked in the office, but I'm working as closely as I can with our tribal courts and with Denise, and I'm glad to be here.
Okay. And bringing up the end of our list is Estelle. You want to introduce yourself?
Good afternoon. This is Estelle Thompson. My Yupik calling names are Angutka and Kakvalga. I'm the oldest granddaughter of Hillary and Maria Gayayoka Jefornik and George and Alice Napoleon. They're all late of Hooper Bay. I'm a tribal consultant. I actually was the tribal court program director for the native village of Pinemute. And I do all sorts of stuff related to traditional wellness, tribal justice, that kind of stuff. And I currently reside in Anchorage.
Okay. So let's jump right in. If you want to go to the next slide. This is week 5, if you guys, if you all can believe it. So I think we're halfway through the Tribal Court Development Series. And week 5, what we're going to do today is talk about the types of hearings that are most common in our tribal courts and some of the procedures. So today's topic is not, our goal is not to cover all of the types of hearings and or procedures, but to really just touch on the main ones that we think you all are either already doing or are planning on doing. And that is the domestic violence protection orders and the 3 different types of hearings, which call for separate or different types of procedures, and then the children's cases. And the children's cases are multiple layered. There's child welfare, there's guardianship, adoption, and there's also others. We don't want to leave out some of the other types of hearings or issues that are being heard. They are for children, they are adoption, child custody, child welfare, which we're going to talk about a little bit. There's also custody and divorces, which I know some tribes are doing. There's trespass, there's drug and alcohol offenses. We get into some of the criminal or minor offenses, whether they're done by committed by adults or by youth. And then there's also some courts that are doing elder protection. So those are all important, but for today's presentation, we do want to focus on domestic violence and children's cases. Next slide, and we're going to jump right in with something that we have already covered, and I'm going to ask Kevin to cover this one. And we're going to repeat this throughout the series. So, but we're not going to, we want you to pay attention, but we're not going to give you a written test at the end.
So the slide on inherent authority is so important because inherent authority or inherent sovereignty really is the primary source of tribal authority to operate your tribal justice system. What this really means is this is a recognition by the United States that the authority to operate a tribal justice system is inherent. It comes from who you are. It comes from your ancestors. It comes from the fact that tribes in Alaska have been self-governing since time immemorial. This inherent sovereignty is something that comes from you. And we have a recognition by the Alaska Supreme Court. Do Alaska Native villages have inherent non-territorial sovereignty, allowing them to resolve domestic disputes? We hold that Alaska Native tribes, by virtue of their inherent powers as sovereign nations, do possess that authority. That's just incredibly powerful language from the Alaska Supreme Court, referring to your tribe as a sovereign nation with inherent authority to take care of your people, to make sure that your communities are a good place to live.
Okay, thanks, Kevin. Next slide, please. Okay, and before we get into the meat of our presentations, I want to encourage people who are online to go ahead and use the chat box if you have any questions, or to raise your hand, or to interrupt at any time if you have any questions. As I said, we've got two major parts. We're going to go over domestic violence protection orders, types of hearings, types of orders, and then we're going to go through children's cases. So you can gauge how you want to ask your questions at that point. And then, of course, after each section, we'll have we'll do a call out for questions as well. So this is we're trying to do as much interactive and get your questions down as possible. So that's what's most important to us. So next slide. So as Kevin just said, we have inherent authority over domestic violence. What this really means is that each of our tribes, each of our villages that have a tribal government, and we are federally recognized and have been in existence for thousands and thousands of years. And the inherent authority means that we have, for those thousands of years, have always looked after ourselves and our citizens, our people that are there. And one of the main basis of our authority is to take care of one another. And this authority is actually codified, is the word. It's been recognized by federal law that we have that. And what the Violence Against Women Act, otherwise known or referred to as VAWA, is an expression of a delegation of authority to tribes. It almost sounds like when they talk like this, that they are giving us authority to do what we've already been doing for thousands of years, when in fact, they're simply recognizing that it exists. So I think it's an important little nuance, a little shift in perception, but it's also very important. So our tribes have the right to and have been taking care of ourselves and each other for a long time. Now, what the VAWA acts, and there's been several of them, the last one being, it'll be referred to as VAWA 2013, which is just the last year that it was renewed or passed through Congress, and it had a lot of things, new things in it. And just so you know that there's another VAWA act that we hope will be, we were hoping that it would actually be passed this year in 2021. If it doesn't, then it will be known as VAWA 2022. And it has not yet been introduced, but will be. And of course, there'll be some updates, some new things in there. So why we refer to VAWA is what the VAWA statutes for purposes of today's presentation and types of hearings that we hear in the tribal court is that the VAWA now 2013 helps our tribes to enforce the protection orders that we issue, that our courts issue. And that's and that these orders then are enforceable no matter where the person who is needing protection goes to, whether it's to another village, whether it's to Anchorage, or whether it's down to Washington State or Oregon or New York. That order can stay valid and can continue to protect the person who the order was taken out on. So that's the importance of that. It's the federal recognition. Next slide, please. And with the types of tribal court hearings that we do have, and these are the most common ones, I'm going to turn it over to Estelle to go over the types of hearings that we have.
Okay, great. Well, as far as protection orders go, there are three main categories that people can apply for. In an emergency protective order, it can be without a hearing, it can be really quick, it could be something that was done over the phone with the judge, and there is usually a great deal of caution about something that's going to happen to a person that is applying for the order. So they're worried that they're going to get hurt, or that there is some threat. There is no notice that's given to the person that is the respondent, and it's usually valid for just a few days. A short-term or ex parte protective order typically lasts about 20 days. It can be issued quickly, just like the emergency protective order also, with or without a hearing. There is no notice that's required to the respondent, and the reason that you apply for a short-term or ex partes is that you believe that there is a cause that somebody is going to hurt you, or hurt your family, or hurt your property. And typically with the short-term protective order, you're given a date, a hearing date for a long-term, if that's something that you're after ultimately. And the long-term is issued after a hearing with notice to the respondent, so that respondent will understand that there's this hearing for a long-term order. And you've heard this in previous presentations. It's just following due process. They're following the next indicated thing. You know, there's a specific order to having these things go through. This word preponderance, it seems like it's kind of, it can be a little bit hard to understand, but there is kind of like this, it's basically an educated guess based upon the previous orders and stuff, and it's valid for a year. It can be valid for a year. So these types of protective orders are in place for you. You can do them within your tribal courts, and then and register them with the state, or send them to your VPOs or VPSOs. Once the order is in place, then a copy is going to be given to the person that applied for it, as well as a copy to the person that they get served, the respondent, the person that the order is against. And then you can provide copies to other agencies. If there's a protective order for the family, if there's minor children involved, you can provide a copy to, let's say, the children's school or their childcare place. So we want to make sure that you follow through with these orders, and also follow through with the chain of the number of people that you provide a copy of that order to, so that people know that this is in place. And if there's a violation, we'll talk about that a little bit later.
Okay, so this is me. We're going to talk about steps in issuing a tribal protective orders, and there aren't very many, but each of these steps could be a little bit more detailed. And I really want to just mention that, you know, your tribal laws and your court procedures to really help you and assist you in the steps that are needed for issuing a tribal protective order. The first step, of course, is that we want to make sure that we're giving our tribal citizens and people that are applying for a DVPO the necessary tools to go ahead and do that. So the first best practice is really to have those forms and instructions available for a petition to be filed. And forms don't have to mirror the Alaska state forms. I know that ABCP has tons of domestic violence forms that are not only in English, but in UPIC with instructional guides on each form to use. And so if your tribe is at a point, your tribal justice system is at a point where you need forms, I would first recommend reaching out to ABCP or even a neighboring tribe. Other organizations have forms and instructions available for use. And again, reach out to ABCP or reach out to any of us, and we're more than happy to provide that to you. But that's going to be really the first step in issuing a tribal protective order. The second step is going to be to really schedule that hearing. And like Estelle just explained, the timeline for scheduling that hearing is really going to depend on the type of protective order that is being asked for. In an ex parte and emergency situation, judges may feel that there may need to be a hearing that's held. Again, notice to the respondent, and both of those are not required, but there may be some additional information that judges need. So if it's a short-term or an emergency hearing, the scheduling of that hearing may be a little bit more quicker than if we were doing a long-term hearing. But the important part of step number 2, scheduling a hearing, is really providing the parties due process. And again, ex parte and emergency don't require notice to respondent. But in a long-term hearing, we want to make sure we're applying due process. And there's a number of reasons why we're doing that. First and foremost is that it's because it's required under the Indian Civil Rights Act. And we know that if we're providing due process, then that's going to guard our tribal court orders against any future challenges for a due process violation. So due process simply means it requires three things. It requires notice, an opportunity to be heard, and it also requires that your judges or decision makers be fair and impartial. Notice is pretty simple. Essentially, we want to tell the parties or everyone involved in the case information about when and where the next tribal court hearing will be held. And also we want to mention what it's about. And the reason why is because it's really giving the parties that fair chance to participate and really work toward fixing the problem or correcting the harm done. When we talk about opportunity to be heard, that quite simply means that we're giving each party the chance to tell their side of the story. And the reason why we do that is because it really helps ensure fairness. It helps ensure that the parties are being heard in tribal court, and it gives the tribal judges that information from both sides to really make that informed decision that they need. We're oftentimes asked, well, are the parties required to speak? And the answer is no, they're not required to speak. The court just needs to simply provide them that opportunity to attend. Parties can choose to attend and not speak, but that second prong of opportunity to be heard, as long as the court is providing that notice and opportunity, then that prong is satisfied. And the third step is really to make sure that our judges are what we consider to be impartial or fair, and make sure that they don't have any conflicts of interest. And we really want to make sure that tribal court judges are neutral and that they're not favoring one party or another. And also another requirement is that the hearings are to be held in a regular, consistent manner. And so when we talk about impartial judges or conflicts of interest, many tribal laws will outline what that looks like. Other tribal laws leave it to the discretion of the judges to really come forward and say, hey, I may have a conflict of interest. Do you want to waive that, or what do you think about it? But it's really a way of making sure that our processes in tribal justice systems are fair and that our judges aren't favoring one side or the other. And so the final step in issuing tribal protective orders is really just making sure that the order is signed. It seems really basic information. We want to make sure it's signed, and we want to make sure that protections that we're issuing in a protective order are specific. And what that means is that if we want to make sure that that the tribal police, the village police, or the troopers have specific detailed information that will allow them to enforce the provisions of the tribal protective order. So for instance, if we're requiring that someone stay away from someone's house, it may say something like, Rick Garcia is required to stay 500 feet from Deborah Oguera's house located at such and such address, Petersburg, Alaska. So when we're drafting our tribal protective orders, it's best practices to make sure that we're including enough information so that troopers or law enforcement or anybody that's going to be assisting with enforcement is able to really look at that order and determine the protections and enforce them without taking time to go back to the tribal court to get clarification. And I think I want to ask Estelle, for a practical standpoint, or Judge Oguera, or anybody, if they have anything else to add for this line.
Estelle, do you have anything?
No, that was very thorough. Thanks, Rick.
There's a question in the chat from Kipnick. Is there a form if they want to stop or take off the protective order?
Yeah, absolutely. And I can jump in and answer that. And I wanted to, I actually wanted to say something more about forms too. There is a form. It's usually a form that is a motion form that's requesting to either dissolve or modify a protection order. And often then you turn that into the court clerk or administrator, and then they will set a hearing. Even if you want to dissolve it, because each party has an opportunity to ask for it to be dissolved, including the respondent. And in this case, the respondent, of course, is the person who's being the person who is restrained from doing anything or not doing anything. And then forms, I know Rick had mentioned something about using, if you don't have your own forms, look to AVCP and or neighboring tribes. I do encourage you to do that because it's always easier to start from a form that's already drafted up than a blank piece of paper, and you are actually more inclined then to get all of the different steps and components in there. I just want to caution everybody, if you do use somebody else's forms, to always look to make sure that the form that you're using actually matches the laws of your tribe. Because you don't want to be enforcing somebody else's laws. You want to be enforcing or adhering to your own laws. So you just want to do a double check and make sure that your law numbers are on the form, or your tribe's name is on the form. So it'll be a step. You can't just take somebody else's form and apply it to your tribe without making some modifications. So I just wanted to cover that.
Awesome. Thanks, Deb.
I think the next back over to Rick.
Thank you. Next slide, please. So enforcement of protective orders. And in Alaska, enforcement of tribal DVPOs, we all know it can be very challenging, but there are quite a few resources here in Alaska that can help with enforcement. And so I want to say the first thing is that tribes have the authority to employ law enforcement officers. So if your tribe has hired tribal police officers or TPOs, that is going to be really your first level of really enforcing your tribal domestic violence protective orders. Additionally, we know that cities oftentimes employ village police department officers or VPOs. And so that is going to be your second level of possibly collaborating with your city officials and the VPOs to find out if there is a way to collaborate to help get enforcement of your tribal DVPOs. Of course, state and municipal police can serve and enforce tribal orders. So we're talking about things such as Bethel Police Department, Alaska State Troopers. That is an option for enforcement. Although again, we all know sometimes it can be difficult, especially in our rural villages in Western Alaska. There is a fourth option, and that is registering your DVPO with the state for enforcement and entry into the national database. We're going to talk a little bit about more about full faith and credit in VAWA and how registration is not required for enforcement, but that is a different and another tool for tribes to use to get enforcement and assistance with the state in enforcing tribal DVPOs. And so finally, there's, we are going to talk more about VAWA, but it's important to note that some law enforcement, they think that they are not required or not required to enforce tribal domestic violence protective orders. But full faith and credit, which is part of VAWA, it's federal law that requires all tribes to, or all, law enforcement officers to enforce tribal domestic violence protective orders as if it were issued by the state of Alaska. And next slide, please. So enforcement challenges. Again, we all know there are enforcement challenges to having state assistance with enforcing tribal domestic violence protective orders. And when we think about the lack of a law enforcement presence, especially in our rural villages, that creates a bigger problem or more of a challenge in getting that enforced. We know that only a third of Alaska villages have local law enforcement. And when we talk about a domestic violence protective order, I think it's really important to talk about the distinction of the piece of paper protective order versus the protections that are issued on that. And so when we are thinking about a protective order, once a protective order is signed by a judge, that's great and it gives protection to the victim for that, but it doesn't become enforceable upon the respondent or the aggressor, let's say, or the person that's harming the victim until that piece of paper is served. And that really makes sense when we're thinking about a notice requirement, when we're thinking about knowledge requirement, right? A respondent or an aggressor or an abuser of a victim, they can't be held liable for protections or regulations, restrictions that they don't know about. So we really need to make sure that when we're thinking about service of domestic violence protective orders, when we're thinking about how we're going to serve that on respondents, either inside our tribes or villages or outside of that, we also should probably think about creating a safety plan, making sure that there's a safety plan in place that in the absence of serving that respondent, how are we going to make sure that the victim is protected? And that's really going to take kind of a holistic, a village, a community approach, and really involving thinking about and having conversations with the tribal council, with their health providers, any behavioral health aides, to really come up with a strategic plan regarding domestic violence or safety plan for the victims. Another avenue of enforcement could be your local air carriers. We've all heard of stories in Western Alaska specifically where tribal DVPOs have been sent to the Raven back in the day, or Grant Airlines or somebody, and saying, hey, listen, this is a tribal DVPO restricting the person's entry into our village. We are hoping that you will help us enforce it. And maybe Deb and Kevin can help me. I was trying to look up information on whether airlines are required to enforce it. I couldn't find any requirement that they are required to enforcement. I don't think they fall under the broad label of a law enforcement officer, but I think there's a great collaboration in Western Alaska specifically that you can work with your airline carriers and say, this person has a tribal domestic violence protective order that's prohibiting them from coming to the community. Will you help me enforce it?
Hey, so Rick, just want to add, I agree with you. They aren't considered law enforcement officers, the air carriers, but they can be held civilly liable for any damages that are done by a person that they fly into the community. So the air carriers have been told by their attorneys that they should not fly people in or they could be held liable for it. So they have the money incentive now.
That's great to hear. So again, part of that, developing that safety plan would be really to just take a collaborative look at the resources available in your villages and those resources that bring people into your villages and tribes, and just have that conversation with them to help support the tribe in their efforts to protect the safety of the tribal citizens. Okay, next slide, please. So I promised we were going to talk about VAWA. Judge Oguera alluded a little bit to VAWA, and I just want to cover really just the full faith and credit aspect of VAWA. And so the full faith and credit provision of the Violence Against Women's Act, it was originally enacted in 1994. It's been reauthorized in 2013. We're hopeful it's going to be reauthorized soon. But since 2013, at least, it has a full faith and credit provision that mandates that law enforcement and courts really recognize and enforce protection orders, and I'm going to put that in air quotes because we'll talk about it for a second, from other U.S. jurisdictions as if they were issued in their jurisdiction. So what does that mean for tribes? And specifically, Section B requires that any protection order that is issued by a state, tribal, or territorial court, if that court has jurisdiction over the parties and the subject matter under the laws, and for instance, I'm going to say here tribe, it requires them to law enforcement officials to fully enforce that protective order as if it were an order of the state. So what does that mean for Alaska? That means that under tribes authority and inherent sovereignty, that if we are issuing a tribal domestic violence protective order that is in alignment with our tribal laws and provides parties with due process, then our law enforcement officials throughout the state of Alaska and downstate should enforce that as if it were issued by the state of Alaska. I think there's another important provision of the Violence Against Women's Act, and it is Section D2. And briefly, it requires that there's no registration requirements as a prerequisite to enforcement. So we talked briefly about how we can have the state help us or assist us in enforcing tribal DVPOs, and that one avenue for doing that is to register it with the state of Alaska court system. That is just an option, but Section D2 requires that the states not implement any type of registration requirements in order for their state law enforcement to enforce it. So although we can do it with the Alaska court system, it is just as effective, and the law enforcement and officers in Alaska should enforce it just as if it were a state court order. If tribes were to email that or fax it or even walk it over to your state trooper's office and say, here's your tribal DVPO, thank you. Yeah, and that's all I have on that. Does anybody have any questions or anybody want to add to that?
So I'm actually going to call on Estelle to see if she has anything to add on enforcement and or challenges to enforcement.
Yeah, well, you brought up some really good points as far as like the fact that some of our communities do not have law enforcement officers available, and in those instances, because of the nature of like our villages and stuff, that's where personally I would encourage a village to register with the state, because that order goes directly to the troopers and is there in place, and in case anything happens, you can go ahead and send it to all your agencies and stuff. The challenges against some protective orders is also jurisdiction. And with some villages, like my village, we have included our jurisdiction to be our tribal members wherever they are, regardless of where they live. And being able to expand that a little bit helps to provide your tribal members with a little bit more protection, because you can work with their local law enforcement officers. And I say that because we had a tribal member in another state at the other end of the country, where we helped intervene on their behalf. We're able to register a protective order against the spouse of our tribal member. And we're able to work with the local authorities within that state, because we claim jurisdiction over that tribal member. So there's different ways of going about this, and it's really all important up to you. I mean, it's dependent on what you think is most important for you and your community, and also how much you can handle. So capacity is another thing that's really important. If you don't have the capacity to be able to serve this order, being able to register it with the state also gives you a little bit more leeway. You have more people that are seeing this order, that have hands on this order, and are able to help you in the enforcement of the order.
Right. Thanks. Thank you, Estelle. So there's a question in the chat. What's the difference between restraining orders and protection orders? So there's essentially no difference. A protection order restrains somebody from doing something, or to prevent them from doing something, or to do something. So I know that some of the tribes and even states are switching over to focus in on protection orders, so that the emphasis is on not restraining somebody, but actually protecting. And it helps keep the judges and others who are tasked with both enforcing and issuing these orders, keeps them focused on the task at hand, which is to ensure protection of whomever it is that's being harmed in one way or the other. So I hope that, I think that's Angela over in that's really good questions. So,
and Deb, I'll have one follow up on that. Angela, I would advise, or I would recommend, excuse me, everyone to use the protective order language. And the reason why is because VAWA specifically applies to protective orders, and I'm not certain, I'm not what I'm looking for, confident that we can rely upon our state counterparts to enforce it. If we write restraining order, if they're going to actually look to the content of that order to see if it really is a protective order, or if they're just going to look to the title of it. So best practices may be to use protective order instead of restraining order, but I agree with Judge Oguera. I think they're essentially the same thing.
Okay.
Yeah, and there's actually a provision. I was just watching a webinar through the National Tribal Justice Conference or something. And they were talked about, there's a website, I'll find the name of the website. There's a website that's specific to VAWA language and protective orders. So I'll find that and send that on to you guys.
Okay, great. And I see Kevin's hand is up. Go ahead, Kevin.
Yeah, thank you. I really appreciate this conversation. Thank you guys very much. I want to make sure that we understand that even though it's called the Violence Against Women Act, that this law applies to women in need of protection. It applies to our elders if they're in need of protection. It certainly applies to children. And when we think about the fact that many victims of domestic violence have 2 or 3 children of their own, it is actually children who are most common victims of domestic violence. So just this idea that any violence in your community can be addressed through this Violence Against Women Act and protective orders.
Okay, thanks, Kevin. That's not exactly what I thought you were going to say, and, which is why I called on you. So I'm going to raise another issue just as a way of wrapping up. I've got a couple of things that have sparked me from the questions and the discussion. A protection order may exclude somebody from going to somebody's house, or even in a small village going to the local grocery store or to a community hall for the duration of the protection order. But also there are tribes and other communities who are looking at doing banishment and or exclusion orders. And sometimes folks will use the protection order process to do that. Our advice to you is, and this goes to just our building relations and making sure that the protection order can be enforced, is to, if there is an individual that is gotten to be so out of hand that he or she is threatening the health and welfare and safety of not just one or two members of a family, but really the entire community or a large portion of the community, then the tribe may be looking at banishment or exclusion from the village. Now, the tribe certainly does have the right to do that. Our advice really is do a separate order with a separate proceeding to do that, and don't tie it in with the protection order, even though it might have started off as domestic violence. It's important for enforcement to have, and making sure that, and this may sound really not fair, but to protect the integrity of the court process, of the justice process, you want to make sure that the person who's being excluded has an opportunity to be heard by whoever's going to be signing, the judge or the decision maker is going to be signing that. And it should take a separate proceeding to do that. And those police officers or law enforcement officers who we're going to most likely be reliant on enforcing such an order are going to be more likely to help enforce it if it's really clear and that due process has been done. Have I done that justice, Kevin?
Yes, and that's our topic for next week. So that's what we're going to be talking about on Tuesday.
Oh, see, I gave everybody a sneak preview. Okay. All right. I want to go back to the dismissals and modifications. I just wanted to make sure, yes, there, and this was an earlier question that Angela had asked. Yes, there's a form. It's really important to understand for those of you who are actually giving information out from the courts to people who are the parties in a protection order, is that just filing the motion to dismiss does not make it dismissed or dissolved. The person who asked for the protection order, once the order is signed, they cannot unilaterally dismiss the order. You do have to go back to the court, go back and have it signed by a judge, ask for it to be dismissed or dissolved, and then that order can be dissolved, but it must be signed. It can be dissolved or modified, but it must be signed by a judge. And the reason for that is having the signed order, dissolving or modifying the order, then gets sent to the law enforcement so that there's, again, no ambiguity or confusion as to what the protection order is saying. So that's really important. Any questions on that? Angela, that was your question. Okay, I'm not hearing anything or seeing any mics come off. So now the other two things, and Estelle covered this, and that's probable cause and preponderance of the evidence. So for the short-term right-of-way order, it's only probable cause standard of proof, and the judge looks at has the offense that is being charged or the risk more likely than not, and that's the measurement. Is it more likely than not? And that's what the judge is going to say. So it's really like you got two stories, they both conflict. Does the judge believe one person just a little bit more? And it's really one of the lowest burdens of proof that is there. In order to get the 1 year, as Estelle said, in order to get a 1 year order, it's by preponderance of the evidence, and that really is the judge, again, taking all the evidence that's been presented, written or through testimony in a court hearing. Then the judge believes one person is truly at risk of harm or has been harmed, either the petitioner or the children involved. Okay, that was a lot. Before we move on to the children's cases, any more questions or comments? Okay. And pay attention to the chat because there's some good resources being put in there, so that's great. All right, hearings on children. As I said in the introduction, we're just going to go through some of them. We're going to go through adoptions and guardianships, custodies, and then we're going to spend a little bit of time on Indian child welfare cases in the state courts and then child welfare cases in the tribal courts. So there's going to be 4 parts to this presentation. And I'm going to start off with Nellie. Next, oh, good, you already switched.
Okay, so in most cases, several tribes can have jurisdiction over children. Tribes should have their own rules for sharing jurisdiction over children's cases with other tribes.
Okay. So next slide, please. So most of our tribal courts or justice systems are going to do at some point or another, or are already doing, adoptions and guardianships. And I put these together because sometimes what happens with adoptions is adoptions have traditionally been part of our culture forever. Whether we're from up north or in the middle of the state, or whether we're from down southeast, I think we all of us Alaska Native people have some kind of traditional acceptance or process or practice of adoptions. Some of them are very informal. Some of them are very calculated. Sometimes somebody who has children and a child has just died in a family in the same village, and another child is born at around the same time. Often, and we've heard stories that the newborn child will be given to the family that just lost a child, especially if there's already a lot of children in the first family. So there's always and there's always the saying, again, no matter what part of the state we are from, that there is no child left without a home, without a family to be raised by. So I think that's important to say, to acknowledge and to remember that adoptions are not foreign to us. That concept is not foreign to any of us and has been going on mostly informally, at least from a Western perspective, informally, but within very formal cultural parameters, depending on what area we're from, or even what culture we are from. So that said, we can, within our court systems, conduct adoptions, and if we want those adoptions to be recognized as formal adoptions by the state, and when I say formal adoptions, I mean the child's last name is going to be changed, a new birth certificate is going to be issued, changing that child's parents from biological parents to the adopted parents, which is what happens in the Western culture. Then there's certain procedures that do need to take place. And because the state, only the state, and this is actually universal across the country, it's the state within which our tribes are located that issue the birth certificates. I have not run across any tribe anywhere, lower 48 or in Alaska, that actually issue their own birth certificates. Now, I could be wrong, and I'd be happy to be wrong on that one, but I don't know of any. So If you want if the child or the adoptive parents want a new birth certificate, then there's a more formal process that needs to be taken. That's the whole message of here. Now, guardianships are also very, is a very alternative option that resembles our traditional cultural adoptions, probably closer, because what they are is, and you can have laws in your tribe that governs the guardianships, they can be very long-term. Once they are made permanent, the guardianships, they last until the child is 18 or until it's dissolved. And children can go into a guardianship with the guardians, and the guardians take on the role of a parent for almost all purposes. Now, some tribes will, in their guardianship laws, will put in that a guardian there's a couple of things that a parent can agree to or give consent to, and for a child that a guardian can't. So there can be some restrictions, such as disenrolling the child from the tribe, and that is a protection of the tribe-child relationship. They can, the guardianship laws can restrict other things like getting married or joining the service or emancipation, which usually requires court proceeding anyway. So a guardianship, again, is the court or justice system making a decision that these parents, the petitioners in this case, the guardians, are able to take care of this child or children, as the case may be. So I didn't have anything else on this that I wanted to do, although there might be some other questions after we've gone through the child welfare section, because a child welfare case, which we'll go into in a minute, can certainly morph into or evolve into either an adoption or a guardianship. Now, the last thing I want to say about adoptions is often, and again, not always, but often, to go through an adoption does require a termination or relinquishment of parental rights by the biological parents, whereas guardianships don't require that. Now, adoptions, and again, that becomes a legality. And I remember doing adoptions where there's been a voluntary relinquishment of parental rights in order for the adoptive parents, the adoption to proceed, and the biological parent agreeing that his or her child should be raised by the adoptive parents. And as I explained, I remember very distinctly one family, I explained that the biological parents, especially if it's an older child who already knows, or you're in a small community where everybody knows who the parents are, you can essentially have 3 or 4 parents. You've got the parents who birthed you, and you've also got the parents who are raising you. And sometimes when it's open like that, the children have continue to have then contact with even more of an extended family than they would, say, in a Western style. So I think the last thing I'm going to do, because I see hands coming up on this to add to it, is that both adoptions, but especially adoptions and guardianships, when you're putting laws together for your tribe, is to really think about and ask the hard questions. What is it that you want your court to do, and does it reflect the values and traditional culture of your community and your tribe? And then with those basic questions answered and put down, you can't go wrong, because your laws are then going to reflect what your community has done or wants to do. All right, I saw Kevin's hand go up first, and then Rick, and then I'll open it up for questions on that.
Thanks, Deb. Yeah, I just wanted to add that while the state almost always does require termination of parental rights for an adoption, this is where it's up to the tribe to define, to write your own laws. I know here in the interior in the TCC region, I've never seen a tribe terminate parental rights in the many adoptions that I've been involved with. Within the interior region, terminating parental rights is seen as letting the parents off the hook. And that's the last thing we want to do. You have a responsibility whether you're carrying through with it or not. So the idea and so this gets back to your comment to the guardianship as an option where you don't have to relinquish parental rights. But again, just the importance of having your own tribal laws on these areas. Thanks.
Right. Rick?
I just want to mention one thing that we've experienced at ANJC. BVS, or Bureau of Vital Statistics, which is now called Human Analytical Vital Records, same division. They have some resources online about what to submit when you're doing a tribal court adoption. Please don't follow them. They are wrong. I had a conversation with BVS about the forms they're requiring and what their website says. So if you need to get a new birth certificate from the state of Alaska, please reach out to Denise and her team, and they can reach out to us. We have some great resources on the correct procedure with the correct forms at ANJC that I'm happy to share. But if you're relying on the state website, you're probably going to get it rejected and sent back to you.
Figures. I had not heard about the new name for their division.
Yeah.
Okay, so that was a mouthful. That was a lot of information. Are there any questions on that before we go to child custody? Okay, so I just want to echo what Rick just said. If you have any questions or you are thinking about doing adoptions or guardianships in your village, in your justice system, in your tribal justice system, reach out to Denise and she can point you in the right direction for what you're doing. Okay. Child custody. Oops, I guess I'm doing that one too. All right. Now, child custody, I'm not going to spend a lot of time on this because the main purpose of having child custody slide in the middle of this children's hearings is to make the point that child custody, and sometimes we just use the key word custody, is between two parents. And whether it's, so you've got two parents who have had a child or more than one child during their relationship, whether they were married or not, they've got a child, and they're either not looking at raising the child together, or they started out raising the child together and now are separating into two households. And they can't make a decision for who the child should live with and who should be the primary parent and who should not, or they have, but they want to make sure that there's an order that establishes that in case there's any disagreements for down the road. Sometimes parents can do really well on agreeing what should happen, but they also just want an order so that there's no misunderstanding. And so custody is between two parents. The tribe is not involved and the state is not involved. And I'll just add, the grandparents are also not involved. It really is between the parents. Now, and I say grandparents because sometimes the grandparents will want to get involved. And I know when I was a judge on some of these domestic relations, grandparents would often come in. And I always thought that it was interesting that they would, I was never sure which side they would come down on, whether they'd come down on their own child taking custody or the other party. So I was always surprised, but I always let them talk because they often had information that the two parents were not sharing with the court. So it was interesting. So they certainly can assist in helping bring civility and calmness to a dispute that two parents may be having, but it really is between two parents. Now, that is opposed to, and I'm just going to set the stage, and before I turn it over to Kevin, ICWA, or Indian Child Welfare cases, are child welfare cases that are in the state court, where there has been either child abuse or neglect and an investigation. Child welfare is the same types of cases, but those are in tribal court. So that's the sort of the terminology that we're using. And with that, I hope I've set the stage correctly for Kevin to take over. Next slide, please.
Thanks, Deb. Yes, so the Indian Child Welfare Act was passed in 1978, and to stop the long-standing removal of Indian children, Native children from their homes. I have to take a second and admit I've talked about the ICWA once already today, and I have a personal bias and a little bit of an interest in the Indian Child Welfare Act, and that my older sister is Hidatsa Sioux from North Dakota, and she was adopted prior to the Indian Child Welfare Act. She's an example of what states were doing and why the Indian Child Welfare Act was passed. She was adopted to my parents because my dad was in the Air Force as a non-Native family, knowing that if they adopted this Indian child to my parents, that she would be taken from the reservation, she would be taken from her home, she would be taken from the state. It was an attempt to destroy her culture. It was an attempt to destroy her tribe. I'm passionate about the Indian Child Welfare Act because my sister's 9 months older than me. We grew up going to the same school. We grew up going to the same classes. And we grew up with people treating us completely different. I, as a white kid with blonde hair, was treated respectfully and nice, and my sister, being Native, was treated terrible. I can't even go into the details. I'm sure all of you know. She struggled with who she was. She struggled with her identity as a kid. It got only worse when suddenly we were teenagers and friends that she had her entire life told her they couldn't be friends with her anymore. All of this because the states, Alaska being one of the worst, were trying to destroy tribes by taking their children. So in 1978, the Indian Child Welfare Act was passed to stop that from happening. As Judge Oguera said, the Indian Child Welfare Act only applies in state court. And this is really important because in the hearings leading up to the passage of this law, Congress found that it's the states that are acting badly. The states are doing wrong in taking away Native children from their homes and from their culture. So the Indian Child Welfare Act puts some restrictions on state courts. So this is a situation where the state of Alaska, the OCS, does an investigation and takes action to remove or investigate our Native children. The Indian Child Welfare Act first requires that the state of Alaska notify the tribe that you know that you have a child in need of aid, that there's a child in the custody of the state. This notification requires the right that the state notify you of your right to intervene. Intervening means you become a party to the case. This is really important because ICWA recognized that it's not just parents, but that the child is important to the future of the tribe as well. Tribes have equal standing as parents do under the Indian Child Welfare Act. In addition to that right to intervene, the Indian Child Welfare Act requires that they provide you with information about how to transfer jurisdiction from the state to the tribe. So the tribe can request that the case be transferred from the state court to the tribal court, where then tribal judges make the decision in the case. Even if the case stays in state court, the Indian Child Welfare Act requires that there's placement preferences. These placement preferences are the main tool to keep children in their homes or in their communities. So these placement preferences require first that the child be placed with a member of their extended family. So rather than children being removed and placed into non-native homes, the Indian Child Welfare Act requires that the children be placed into a member of their extended family. If there's no family, extended family for the child to be placed in, then the child must be placed in another native home. Only if there's no other native homes at all that can take the child can a child be placed into a non-native home. These placement preferences are so important for keeping children within their culture, their communities, hopefully their families. If you go to the next slide, please. But it's important to remember the Indian Child Welfare Act only applies in the state court when the state's taken action. And that's because states are the ones that have done wrong historically in taking Native children from their homes. Now, my advice to you is the way to stop the state from taking children from their homes is not to let these become state court cases. Your tribe should act early. If we hear that the state's investigating, OCS is investigating a family, our tribe should take custody of that case. Make it a tribal child welfare case. Once it's a tribal child welfare case, that stops the state from taking the case. It keeps it in tribal court. So we never have to go around the circle into state court to begin with. Your tribe can have rules similar to the Indian Child Welfare Act and placement preferences, but remember, ICWA, the law, really only applies to tribes because of this, or the state, because of this poor history of the state removing children from their homes. And with that, I'll turn it back to you, Deb.
I'm actually going to call on Estelle to see if she has any thing to add to the ICWA portion of this.
Sorry, my mouse was not working. Yeah, I totally agree with Kevin, and I really feel for your sister, Kevin, because we've heard way too many stories in our communities related to situations just like that. And one of the things with ICWA is it's so important that we allow ourselves to follow this and protect our children. Not only, just like Deb said, not only for the child themselves, but also for our communities. And there's a lot. I think we'll have to have a different session on this. One of the things that I wanted to mention is, like, within some of those protective orders that we talked about earlier, there may be provisions for the protection of the children, and it's really important to keep those things, the protection of the children, in mind when it comes to custody and, you know, possible removal of children from homes and that type of thing.
Okay, thanks, Estelle. Next slide, Denise. So this goes off from what Estelle and Kevin just said. The best protection for our children is to head them off if there's parents who are abusing or being neglectful, for the tribes to intervene. Now, of course, that takes resources, it takes money, it takes court and social services. Some tribes don't have that, but you know, it's just a matter of figuring out how to first setting that priority, and then looking for the funds and making plans for that. Child protection is a very important part, and it certainly is a lot easier to start a child protection case at the tribe first than letting the state, having the state open that up and then trying to get it transferred over. It actually becomes quite complicated, and often you need an attorney or a very forceful advocate in your tribe that can go to tribal court and advocate for that transfer. So To start a child, so this next section we're going to just talk about, and we're going to go through, I'm just looking at the time, we're going to go through fairly quickly, but you all have the slides, so it's pretty detailed slides, and we're just going to go through it fairly quickly about the steps for your tribes that want to start child protection cases outside of the state, not involve the state at all. So the first thing that you want to do is you have some kind of a unit that's doing investigation who is able to go out on calls to investigate. There's been reports or information submitted that where children are either being abused or neglected, and the abuse can be abandonment, it can be physical, emotional, sexual abuse, any number of things. And the first step that you are wanting to do is report that and have an investigation. If the investigation actually concludes that there's a risk of harm or that harm has been done or is being done, then a petition gets filed with the court. Next slide, please. Then your court will need to decide whether or not to take legal custody. And I just want to say there's two different types of custody in a child welfare case, child protection case. One is legal custody, which means that family and those children and the children's caretakers are going to be under the supervision of the court, of the tribe. And physical custody is the children are going to be removed from the parent's household because it's too risky to keep them there, and they're going to be moved to another home. And as Kevin mentioned, in your child protection laws, you can put together or include the same types of preferences, placement preferences that are in the ICWA statute, but you can do even stronger ones or more relaxed ones. It really is up to you. Conditions of the child custody and physical custody have been decided are really up to first the evidence that is presented and the recommendations from the investigator and or the social services. And there's a number of things. The children can be placed in with relatives. Children can be placed in foster care, especially if you've got foster care homes in your village, or if there's no services for the children in your village, to a neighboring village or to an urban area. But again, you want to set those out. You also want, in a child protection case, the court will set out actual conditions and requirements that are aimed for the parents to resolve or address the issues that brought the case to the attention of the tribe in the first place. If they're abusing or neglecting the children because of drugs or alcohol, then certainly treatment, assessment and treatment is going to be one of the things. If it really is just not having parenting skills, then certainly some training and parenting classes, either there in the village or online, is going to happen. Next slide, please. And Estelle, I'm going to turn this over to you to go through some of the basic steps that happen in a hearing. You've gone through the hearings, is it right?
Yeah.
Go ahead.
Well, this slide is all about why we have, or ways that child protection cases are heard in Alaska. The basic steps are the case starts with a petition in the tribal court, or a report of harm from a mandated reporter like a teacher or health aide, or somebody else comes in. The tribe has a responsibility to investigate the allegations in the petition. So they look and see how much of the allegations they can prove or get from testimony, and decide whether or not they can hear the case. Some cases tribes will not hear, or they will defer it to a state agency or another agency, a private agency within the region. Part of these protection cases can include the protective orders like we talked about before. Mm-hmm. And in some instances, if there are children and minor children involved in a protective order, there will be stipulations written within that protective order about the minor children. Like the petitioner can request that the respondent parent, the person that they're applying for the order against, will not have physical contact with the children, or they will not have phone contact with the children. They'll not go to the child's school or try to take them out, that kind of stuff. So all that language should be in the protective order and be very, very clear, especially when it comes to the kids. There might be stipulations if, like Judge Oguera said, if there's some sort of alcohol or drug problem, for if there's like a visitation portion in that order, that the parent that is getting visitation not use or drink within so many hours, or not use or drink at all. And it's really important that this order is very clear, because if there's something that happens, let's say a parent who has visitation is not supposed to be drinking and they get drunk, you can call the local law enforcement or the troopers or whatever and say, this person has violated this order and we need to make sure that we can pull those kids and make sure they're safe. So that talks about the immediate or imminent danger within that emergency order. Notice needs to go to all parties. So it needs to go to the petitioner, it needs to go to the respondent, and anybody related to those children, whether it be their school, their child care provider, the local law enforcement, the health clinic, and as we mentioned before, maybe even the airline agents, like Grant or Raven or whoever services your community. Before the actual hearing, there should be a draft case plan and recommendations by an ICWA or tribal social worker. Here in Anchorage, there's a department within the Cook Inlet Tribal Council that has a social worker that works with families to come up with recommendations, if I remember correctly. And all those things can be put into the hearing and into drafting an order and like a plan for the kids. And when it comes to the kids, we really should have a comprehensive plan for them, because their safety is dependent on how thorough we can be.
Thanks, Estelle. Next slide, please, Denise. So I totally agree that the case plan is really, really important. The parents need to know what it is that they need to do in order to remedy what caused the risk of harm or the harm to begin with. And they need to be given a chance to correct that if they are able to do that. If not, then the case is going to end in either adoption or guardianship and not have the children returned to the parents. Though most all of the child welfare children's laws that I have seen that tribes have done is the main focus is to reunite the children with the parents. And in order to do that, the court and the court resources, the social service resources that the tribe has to offer need to be sufficient to help the parents remedy the behavior that caused the case to come to the attention of the court in the first place. And so all of the hearings, so there's not just one or two hearings. Once the case has gotten to the court, there's going to be periodic hearings. And for anybody who has gone through the state court, those hearings can be 6, 9, sometimes 12 months apart, which is not enough to give the parents enough attention to know that they, and check-ins to show consequences for not complying with the case plan or rewards for complying with the case plan. So it's really set up for failure. And we want our tribal programs to be set up for success of the parents remedying their deficiencies as parents and for the safety of the children. And we don't want the children to have to be left in an unsafe home, but we also want the children to also not be put in the position, as we so often see children who are left in neglectful homes, having to be the parent or the adult way too early. So there's, so your laws and provisions will need to focus in on a lot of review hearings, a lot of reports, and a lot of check-ins by the judge and or the court advocate on progress. So that's what this is doing. And again, it's not up to the parents or even the extended family to determine that. Once the case is filed with the court, the judge decides that. And you want your laws to be very, very clear about what are the parameters that you want your judges to follow. So if it's not in the laws, the judge can't follow it. So do find that out. Do check on that. Okay. Now that's a lot on child welfare and ICWA. Is there any questions? We've got like 4 more minutes left of the presentation, but before we go on to the next step, I just want to let folks ask any questions if they have any. We've hit you with a lot of information. Anything? Okay. And if your mic's not working or you you can also just type it in the chat. Several of us are monitoring the chat. Next slide.
Sorry, just a reminder for everybody to unmute yourself on the phone. It's *6. So if you're trying to speak and you're muted, please press *6.
Great. Okay. Some other types of cases that we haven't explored that pertain to families and domestic relations is child support. I'm just going to share with you that that the Tlingit and Haida Court in March of 2007 opened its doors and only did child support, and that was through a federal direct funding for child support, issuing child support orders and enforcement, and was a collaboration with the state, and they'll received and they actually still do receive direct funding. So there was no custody cases, there was no DV, there was no child welfare cases. It was only for, I think, the first 3.5, 4 years of Tlingit and Haida, which is actually now a fairly large court that's been in operation for 15 years now and is doing a myriad of types of issues and cases, was only doing child support. And that's how my tribe, Tlingit and Haida, actually was able to have the resources and the funding to hire court staff and get the forms and the furniture and the stamps and the Xerox machine and all of that stuff to get it set up. So it's certainly one area. And the child support I've separated out from child custody, even though it usually is a part of child custody, but it can also be part of a guardianship. So it's that idea that parents are parents and have the responsibility for providing financial support for their children. But I'll just share with you Tlingit and Haida's philosophy and purpose of their stated objective for the child support division that's still in operation today is that the children of the tribe have the right to be supported by both of their parents to the best of their ability. And sometimes that's only $25 and sometimes it's $500. And for those of you who have children know it costs a lot more than $25 to raise a child. But the philosophy is that if a parent, even if it's only $25 that they are contributing to that child's support, and they're actually able to pay it, that parent is actually more likely than not to be involved with their children. And if they are involved, so is the extended family of that child. So again, the focus is on the child. The other types of cases that you can do, though very few tribes are doing it because it's very complex and you need a lot of resources to do it correctly, and that's estate and probate. For when somebody has died and has left a will, and then or has died and not left a will, figuring out what to do with that person's property, not just money, but also land, houses, and other things. Sometimes cultural regalia. And because the tribes aren't, most of the tribes are not currently doing probate cases, those cases often get land in the state courts. Next slide, please. And this is our last, where'd those all come from? Holy smokes. All right, I'm going to go through these real fast. I'm not going to read them. Kevin, you're supposed to do it, but I don't think we have time.
Yeah, Deb, I do want to add to your comments on child support that while we often think of child support as money, tribes are able to order non-monetary child support. Yep. So they have to provide duck, they have to provide meat, food.
Firewood, house repairs.
All these types of cases that we had listed here really isn't to overwhelm you. And I'm afraid sometimes when you get lawyers like us talking about tribal court, we use big words and make it sound more difficult than it is. The real point here is that tribes are doing some really great things across the state of Alaska. And while no one tribe does all of these things, there are tribes that do all sorts of things across the state of Alaska with no resources. We're finally getting a little bit of money. And this really is to encourage all of you to just take that step and start hearing cases. Just do it with your tribal court.
Yep.
Thanks, Deb.
Next slide. Here's a list of possible youth-oriented cases that you can do. You can have a separate youth court. Next slide. And then just a couple of the things that are able, just again, what Kevin was just saying, some of the consequences, punishment, sanctions, just the accountability of somebody who is either offending or is owed something, they have a responsibility, or they've done something to somebody. How do we make that whole? How do we both hold the person who's behaving badly accountable, but also reimburse or reciprocate the repair the harm that's been done? So these are just some things that the court can do, and you can either empower your judge to be creative, or you can list all these. You can be very, very concrete and list possible sanctions in your laws, which I don't recommend, because creativity, I think, is really good. Next slide. And then just some more ideas about consequences. And sometimes, I'll tell you, way back, this is real briefly, but when I was the prosecutor at the Puyallup Court, we organized a court of elders for the youth offenders. The school kept sending me 12, 13, 14-year-olds who were not coming to school or fighting at school or doing not doing things and I chose not to prosecute them as adults, or actually not prosecute them at all. We formed a court of elders that youth had to go appear before and explain to them what they were doing and why, and the elders gave them consequences, and it was very effective. So be creative with your consequences and aim for teaching lessons rather than punishment is the key. And last slide. Well, we didn't leave any time at the end, Denise.
Yeah, it is right at time, but I did want to ask quickly if there are any questions or comments for our presenters. It was a lot of information today, a lot of really good information. So I just wanted to ask anybody in the audience if there are any questions or comments. Please remember to *6 if you're on the phone, and ask your questions if you have them.
It's Estelle. I just wanted to remind everybody, this does seem like it's a lot of information, but you have to remember that the Western justice system is only like several hundred years here in the United States, and we've been governing ourselves and taking care of our own communities, building and keeping those relationships for thousands of years. So when you start thinking about how monumental this might seem like in Western terms, think about how we run our communities, our families, and everything like that. And honestly, it's really not as difficult as it seems. There's lots of words that we may be unfamiliar with, or terminology, but we've been successfully doing this for thousands of years. So please do not be intimidated by all this this Western talk and these forms. We have the capability to do this confidently, successfully, and we have for thousands of years.
Thanks, Estelle. I always get really happy when anybody says things like that. And then also remembering that I've been telling everybody that your closest resource could be the village next door, the court next door. So just to always remember to reach out and don't be shy about it, because even asking could lead you to great things. So if there are no further questions or comments, I just want to thank everybody for joining us today. Thank you to all of our presenters for all of the really wonderful information. It was a really good session today. So like Kevin said earlier, we're going to be talking next week on Tuesday from 2 to 3:30 about banishment. So we'll welcome you back for that. If anybody has any questions that they want to ask us afterwards, feel free to reach out to the Tribal Justice Department, tribal-justice@avcp.org or 543-8550. Thank you, everybody. Have a great day.
Thanks, everybody.
Thanks everyone. Have a good day.
Kelly.
Diana.
Bye, guys.
Bye, Rick.